that kind of patience. So we created this abbreviated version to provide you with only the very essential information on liability insurance. So I have a lot of material to get through in 15 minutes. I'm going to ask you to please hold your questions until the end, and then I promise I'll stay on as long as necessary to get to all of your questions and get them answered. Professional liability exposure for federal wildland firefighters really changed dramatically in 2001 in the wake after the infamous 30-mile fire. In the aftermath of the 30-mile fire, Congress, and it was spearheaded by Senator Cantwell, I like to say, in all her infamous wisdom, it created a law, a public law, 107-203, and this law required, mandated, that the USDA Office of Inspector General had to conduct an independent investigation into each fatality or serious injury due to a wildland entrapment or burnover. And it's important to emphasize here, this is Forest Service, USDA only. And I'll be talking a lot in terms of Forest Service, and I realize we have firefighters who are under Department of Interior, BLM, and other firefighting agencies. I suspect that a lot of these concepts are going to start applying across the board to each of your agencies, so I believe they have very similar implications and applications. And in the wake of this new public law, the true impact became a real harsh reality when we had the next fire tragedy, which is called the Kramer Fire. And in this, we learned that the USDA IG came in and actually conducted a manslaughter investigation against the managers who were in charge of the fire to see if there was criminal negligence. And I think this took everybody by surprise. Nobody truly appreciated that the IG was going to come in and treat this as a criminal investigation. But when you take another look at it, IGs are criminal first. They're going to look at criminal allegations first before they move on to administrative allegations. So this is what they did. And we'll talk more about what happened in those cases in a little bit. The 30-mile and the public law also changed the accountability landscape in that it was the very first time that the Forest Service really imposed serious discipline against employees involved with managing and fighting the fire. Investigations used to be about lessons learned, to prevent future tragedies, future mistakes, but now we're finding out that they're all about assigning blame and what we call accountability. We're going to start out with the civil exposures. There are three areas of exposures I should mention: civil, administrative, and criminal. We're going to start out with civil and quickly go through it because, believe it or not, civil should really be the least of your concerns. Civil actions are usually, you'll hear them called Bivens actions, constitutional torts, personal capacity or individual capacity lawsuits. You don't have absolute immunity for these kinds of lawsuits like you do for lawsuits under the Federal Tort Claims Act. The reason that I say these types of cases are going to be rare against the federal wildland firefighter is because in serious injuries involving firefighters and fatalities involving firefighters or other agency employees, the Federal Employees Compensation Act, FECA, is going to be the sole remedy. So they're not allowed to sue other individuals personally. And then if it involves someone outside of the agency, by and large, the Federal Tort Claims Act, which gives you absolute immunity, usually takes care of most of these matters. But there are cases where you can't be sued personally, so we want you to understand that, and we want to introduce these three basic concepts to you: representation, immunity, and indemnification. First, representation. If you get sued, the first thing you need to consider is who's going to defend you. DOJ representation, believe it or not, is not mandatory. It's not automatic. It is the sole discretion of DOJ to decide whether you will be assigned a DOJ attorney to defend you. Even if it's clear that you are acting within the scope of your employment, DOJ must also determine that it's in the interest of the United States to provide you with defense counsel. A denial in this circumstances usually happens if, let's say, you're being investigated for some sort of wrongdoing for the very same reason that you're being sued. You can see that the Department of Justice can't be on both sides of that, so you can be left on your own to defend unless you had Fed's professional liability insurance policy. The next concept is immunity, and I've already alluded to it. You don't have absolute immunity for these personal capacity lawsuits like you do for FTCA lawsuits. You only have what's called qualified immunity, which is still pretty good. The final concept is indemnification, which what you need to understand is even if you're scoped, interest in the United States, and DOJ is actually representing you, it's still a case against you personally. So if they represent you and they lose, you can still be held personally liable. And that's where this concept of indemnification comes in. The Fed's policy gives you $1 million or $2 million of indemnity protection if you are found personally liable and your agency declines to indemnify you. The test for indemnification is, again, scope of employment, interest of the United States, and your agency must have regulations governing the indemnification process. What you should take away from this brief discussion for civil exposure are what I call these two sets of threes, okay? You need to appreciate that you can be sued personally, DOJ can deny representation, and you can be held liable for a judgment. And then the other three things I want you to take away is the PLI protects you in these three major ways. It provides a legal defense, it pays damages, and it will also provide something that's called coverage counsel. And there's two parts of this. If DOJ is on the fence as to whether it will rep you, we'll hire coverage counsel to convince them that they should rep you, and in certain cases, we'll appoint coverage counsel to oversee the DOJ representation of you. Before I leave civil, in the interest of full disclosure, I do want to emphasize that civil suits without DOJ representation are very rare, with actual liability being even rarer. If some of you attend liability courses or talks by your agency lawyers, Department of Justice, AUSA lawyers, and they recommend against buying liability insurance, they say you don't need it, this is what they're talking about. This is the area that they're talking about, is they look at it from a civil perspective only, and they just think the risks aren't that great, so you don't need to buy the insurance. What these instructors don't appreciate is that your biggest bang for your buck is going to be the next two exposure areas that I'm talking about, criminal and administrative, and even the small amount of civil exposure that you have for $135 a year, which is what it costs after you get reimbursed. Why would you risk it? Why would you want to be the one that slips through the cracks? So let's start with criminal investigations as the next liability area that I want to talk about, because this is the most serious. This is beyond your job. This involves your liberty. This could involve you going to jail. In the wake of 30 Mile and the new public law, the IG, as I mentioned, comes in and runs initially in a criminal investigation. And what they're looking at, they're looking at manslaughter. Did the manager recklessly, manage and supervise the fire? They'll look at things such as falsifications during the investigations, false statements, obstruction of justice. Some other things you should know about these criminal investigations is that they're supervised by federal prosecutors, Department of Justice, typically referred to as assistant United States attorneys. The most important thing to know about these criminal investigations is that by and large, the request to interview you by a criminal investigator is going to be what we call a voluntary request or a Garrity request. That means you have a Fifth Amendment right to silence, and you absolutely should not speak to an investigator in a criminal investigation without first talking to a criminal defense attorney. And when a criminal investigation will often run, in these situations, will run parallel to administrative investigation, the matter invokes some very complicated constitutional issues. Waiving your constitutional right against self-incrimination is just something you cannot do, okay, without consulting an attorney first. These are some of the criminal offenses that the IG will typically look at. And a little bit later, I'll go through the pecking order of the investigations and what your rights are and what you should really do for each. As most of you know, there's an accident investigation. There's an OSHA investigation. OSHA comes in, wants to tell you how to keep a burning forest a safe working environment. There'll be this OIG investigation that I'm talking about. And then in the end, often there's this misconduct or what's called an accountability investigation. But for now, I just want you to understand that there is criminal exposure when a wildland fire goes bad and a fatality or serious injury occurs. And I'll quickly talk about the two most biggest examples in the firefighter community, which is the Kramer fire and the 30 Mile. First, the Kramer fire, even though Kramer, which was it was in Salmon, Idaho, even though this was technically after the 30 Mile fire, it was the very first time that the IG conducted its investigation under this new authority. And in this case, the outcome, the IC, the incident commander, who was the main subject of the criminal manslaughter investigation, ended up accepting what's called a pretrial diversion plea, which involved him resigning his federal employment. The Forest Service and Department of Justice in this case really put Allen in an untenable position and proceeded on two fronts against him. They proposed a removal action while the criminal investigation was ongoing, so he couldn't practically defend in the administrative disciplinary matter while the criminal matter was ongoing. And moreover, he didn't have liability insurance. He didn't have the money to do a viable, criminal defense. It was pretty much cost prohibitive to him. So he essentially took this deal. Never had an opportunity, to defend himself. Those of you who know about the Kramer fire, say what you want about it, say what you want about the IC, but for my money, he was not a criminal, and the fact that he never had an opportunity to at least defend himself is something that really bothers me to this day. The other prosecution happened in 2007, some 5 years after the 30 Mile fire. The IC was indicted in that case and was indicted for involuntary manslaughter and several counts of Section 101, 1001, 1001, which is false statements. And in that case, ultimately there was a plea deal that the IC pled out to a 1001 charge, and it was unfortunate. In the interest of time, I'm going to need to move on here, but in the question and answer period, I could provide more information on both of these criminal investigations. But for now, I want to move on. I will point out before leaving criminal real quick that it's just one little editorial note from my perspective, and so I could take a little shot at the IG here. It's interesting to me that, at least initially, the IG's lack of experience in investigating these types of manslaughter crimes or experience in investigating wildland firefighting fatalities, it ended up in them relying heavily on the accident investigation, which is what Congress didn't want to begin with. But to be fair to them, now that we're several years into this, they've established a specialized unit that's designed to specifically look into these mishaps. So the next final types of exposure area that you have is what we call administrative. The Fed's liability policy pays for legal defense for up to $200,000 for any administrative investigation that could result in a personnel action against you. So this is any administrative investigation, whether it's the OIG, whether it's OSHA, whether it's a serious accident, whether it's a misconduct investigation. We will appoint you a lawyer at the beginning of the investigation and defend throughout. In the unfortunate event that there's a disciplinary action taken against you, we'll defend both at the agency level, and if we have to appeal to the MSPB, your representation provides that defense as well. What you need to appreciate here is whether your actions are intentional, unintentional, you need to really realize that they are going to be reviewed from the perch of 20/20 hindsight, okay? And as you know, with the benefit of this kind of hindsight and just the general pliable nature of the 10 standing fire orders, the 18 watch-out situations, the safety rules in the Red Book, it's not hard to find violations when you're looking back at this and second-guessing decisions, even in the most safety-conscious environments. Again, as I mentioned, the liability policy would provide you an attorney to defend throughout the investigation and the disciplinary action if one happens. These are the typical disciplinary actions that you see in these situations: suspensions, demotions, removals. And they're usually based upon a combination of the accident investigation, OSHA's findings, and the accountability investigation. These are just an outline of some of the charges that we've seen when they've conducted the misconduct administrative investigation involving mishaps in the wildland fire situations. And with the exception of the work-rest ratio, you can kind of see how any one of these types of charges, can be manipulated to serve a purpose. The means to justify an end, in other words. They're very pliable. Here, and this is what I think is the most important slide and most important thing that I can teach you today. Second to that you need the liability insurance is to understand what your rights are in various investigations. There are two types of interviews for all the investigations that we talked about, whether it's IG, OSHA, accident, administrative, any kind of investigation. There are two types of interviews that they will do. One's a voluntary, or you'll hear it called garrity. One's called a compelled, or you'll hear it called calkines. We almost always want the interview to be compelled, a calkines type interview, because that gives you what's called use immunity. Anything you say cannot be used against you in a criminal matter. So the typical way this works now, and it's working a little bit better now that the IG has better experience in handling these cases. I'll quickly go through the way it worked in the Esperanza fire, which I thought was perfect and excellent, and was one where it really respected the federal employees' rights. The initial accident investigation, the requests to be interviewed were initially voluntary. Okay? Voluntary means that you can decline to be interviewed. Anybody who was represented by me during that investigation and the request to be interviewed was a voluntary one, they declined. Okay? Very quickly, the Forest Service obtained what's called a declination of prosecution. Then they were able to compel the interview, meaning you have to participate and you have to be interviewed. That's what we want, because that gives you use immunity. And the only reason that the Forest Service was able to do that in this situation is because the IG recognized that if it was going to be involved in this investigation at the onset, immediately after, within the 72-hour period after the fatality, it was going to disrupt the ability for the Forest Service to really do a meaningful administrative investigation. Because if the IG again is looking over their shoulders, lawyers are not going to advise them to participate in those interviews. So the IG, went away. And then after this investigation, the IG came back in, and after having got its own declination of prosecution, was able to compel the interviews. Therefore, the employees could participate without fear of being prosecuted criminally. Again, if the request is voluntary, you do not want to speak to anybody, any investigative entity, without getting legal counsel. That involves you waiving your Fifth Amendment right to silence. This is just a quick summary of what the insurance provides. Another very important concept I want to hit before I open it up to questions is Congress has authorized legislation for the agency to pay for half of these for many of you who are involved in fighting fire. And this was expanded in the wake of the public law, in the wake of the 30-mile tragedy. It was expanded to include managers and supervisors who are just managers and supervisors on a fire. So if you have the capability to be an IC3, IC4, even though your day job may not involve you being a manager, supervisor, or law enforcement officer, if you have the capability to be a manager on a fire, this 50% reimbursement applies to you. It's called Enclosure A, that enumerates, Forest Service Enclosure A, that enumerates all the positions that are eligible for the reimbursement. When I say Enclosure A, it's Enclosure A to their professional liability insurance reimbursement policy. It's on our website. If you can't find it, just give us a call. We'll point it out to you. For folks that are with other agencies, Interior, other firefighting agencies, just get on your agency's intranet and type in federal employee professional liability reimbursement, and your agency's policy should pop up, and you'll find out whether you can get reimbursed or not. The cost of the policy is $270 for the $1 million, $370 for $2 million. Agency pays for half of that. It's as little as $135. Okay, that's it. Annual premium, and you could pay by virtue of payroll deduction. I can't tell you how many times that we have people calling here after something has happened, after the incident. You know what I call calling after their house is on fire. This insurance works just like other insurances. You need to have it in place prior to something happening. There are 3 ways to get enrolled. You can get online. It takes less than 5 minutes. We can send you an enrollment form. You can call us. We'll enroll you over the phone. It takes less than 5 minutes. You print your certificate of insurance right there, and you get your reimbursement certificate with that you turn into your agency. If you're at the Forest Service, you process that down through Albuquerque in New Mexico. So before I open up in questions, I just want to emphasize that I hope you learned today that serious accidents on wildland fire do occur. Most of you know that. Accountability allegations against federal firefighters are not uncommon. Legal advice, attorney services, as you know, are relatively expensive. The liability insurance is relatively cheap. And performing your firefighter responsibilities in even the most safety-conscious way is no guarantee that you'll be immune from these professional exposures if an incident happens. So I went about 10 minutes long here, so I'd like to open it up for questions.
Tony, believe it or not, we have no questions, so I'm going to give it a minute or two before I let you go. Tony, we have never had this happen before, so you must have done a great job. Okay, we have one pop-up. When I logged on, it said that all participants were muted. That does happen. That is so that Tony has the floor.
That's so I can guarantee that all questions are held to the end.
Tony, someone is asking if he can ask a question verbally.
Yes.
Okay, I'm going to unmute Dylan here.
Hello?
Hi, Dylan?
Yes. Hey, I'm going to be starting my federal career as a GS4 crew member on a hotshot crew with the BLM this summer. My question is whether a person like me who's not going to be in a supervisory position, if you suggest someone like me gets the insurance.
I believe strongly, and particularly with firefighters, moreover than any other profession, that this insurance is important. Even though your exposure, honestly, is not as much as your superintendent, your hotshot superintendent, or other managers, or folks who are going to be ICs. If you're on, a hotshot crew or working on, a fire in general, there still is the possibility for some exposure if somebody's going to accuse you of a safety violation. Even though you're not managing the fire, you could be accused of allegedly, failing to do something or not to, failing not to do something or do something that is unsafe, and there still could be liability against you. I liken this to title insurance. It's something that you just really have to get. If you were my brother, I'd buy it for you, so to speak. So it's even though you may not qualify for the reimbursement for your position, it's only $270, and just think about what we spend money on these days and how quickly that goes.
Well, thank you.
You bet. Any other questions, Kathy?
Yes, Tony, we have. Would you cover the Kramer and 30 Mile in more depth, how the investigations went?
Sure. Let's start with 30 Mile first, because it was all done backwards. What happened, and because it was what kind of started everything. In the 30 Mile, they originally came in and did what's called the accident investigation, or what's been infamously called the Furnish report. Jim Furnish was an agency employee, and he was the head of the accident investigation team, and they prepared the serious accident investigation, which was the first types of investigation, and everybody cooperated with the investigation and testified the best of their ability, because there weren't all these concerns about criminal exposure and accountability exposure then. And the Furnish report was released, and it was very controversial. If anybody has studied the 30 Mile fire, the kids, and I say kids because they were very young, who died were largely on the rocks and not on the flat ground where the IC was asking them to come to when you had to deploy their shelters. Why that happened, is very complicated. My opinion, it really didn't matter. That's just where the fire laid down that way, unfortunately. But when the report was released, it essentially alluded to, and suggested that the kids who perished, it was part of their own fault. They shouldn't have been up there. They should have been on the road. And that created a lot of backlash, obviously upset the parents very much, and ended up resulting in what I think is a public law that ultimately happened that Cantwell spearheaded. And then what happened in the wake of that, there was this misconduct accountability investigation. We called a Lynch investigation. Stephanie Lynch was an investigator, came in and did, again, interviews and did what we call a misconduct investigation. And then disciplinary action was proposed against about 11 or 12 individuals involved on the fire. And the employees were able to defend. Some had union representation. 4 had liability insurance and were able to get adequate legal defense. One of the things in those disciplinary actions I could tell you that upset a lot of the employees the most is they tied a causal connection to whatever they alleged that they did wrong to the fatalities. So whether or not you could handle a 2-day, 3-day suspension was nothing compared to sort of the psychological harm, that they did to a lot of these employees by drawing this causal connection. So those were the initial investigations, and then some 5 years later, almost beyond the statute of limitations, the Department of Justice, the district up in Washington, opened a criminal investigation, and that's unusual. And it came in and looked at all this stuff where people provided all this voluntary information, and that's when they charged the IC, L. Reese Daniels, for the charges I discussed. And fortunately, L. Reese was defended by a very talented federal public defender, and she ended up getting a really good deal for him. So that's 30 Mile. And then the Kramer is what happened in more of a sequence, as it should. As it should, and then sort of as it should not. I'll explain later. What happens is all the investigative entities showed up at once. You had the IG, you had OSHA, you had the accident investigation, and all that was ongoing at the same time. So in my opinion, it really trampled all over the employees' rights to remain silent in a criminal investigation, because they were testifying in what should be an administrative investigation where they should be getting compelled warnings, should be required, yet the IG can have access to all that. And it really created a difficult dichotomy there. And then what happened is, while the investigation was ongoing, the agency, wanting to take its administrative action, proposed actions against the IC, was removal, and then other disciplinary actions against the district ranger and other fire management officers who were involved. And folks had to decide whether they were going to defend, knowing that this criminal investigation was still ongoing. And if you're a subject of a criminal investigation like Alan Hackett was, no criminal defense attorney is going to allow you to provide evidence that they can just turn around and use against you in an administrative matter. Other people were able to defend because the Department of Justice specifically ruled them out as subjects in the criminal investigation. So they were able to defend, even though there was a lot of posturing and arguing by defense counsel to get the Forest Service to really postpone that till after Department of Justice was done. Then you add all that up for what happened in the Esperanza fire, which is what I alluded to, that I think they're getting it right now, is the IG knows that this accident investigation needs to happen. They know that if they're going to be involved, within the 72-hour period, they're going to disrupt that. Okay, and then the Forest Service understands now what compelled and voluntary use immunity. They understand what all that means and why it's important for employees. So they work aggressively immediately in these situations, and they're able to get what's called a declination of prosecution, and then they feel comfortable that they're able to compel the testimony, require the testimony, so they can get an adequate report done, so that they can do lessons learned and things can be done better and more safely in the future. Then the IG can come in and look at everything at a later date, and they can decide whether they want to run a criminal investigation or whether they want strictly an administrative one. In Esperanza, they quickly ruled out any criminal allegations.
Okay, Tony, we do have quite a few more questions building up now. May I interrupt?
Yeah, I'm done.
Could you explain the voluntary or compelled testimony differences again, please?
Sure. And it's complicated, and in 15 minutes it's so hard, for me to lay it out in a way that you'll understand it. I've had lawyers that have worked for me that take months to understand it. But what you need to understand is voluntary means that it's voluntary. Okay, you cannot be disciplined. There cannot be a job action against you for exercising your right to silence. Okay, it's voluntary. Compelled means that as a condition of your employment, you have to answer the questions, you have to provide testimony, okay? Because that essentially is forcing you to waive your other constitutional right to silence. Then what you get out of that is use immunity. Immunity from anything that you say during that compelled interview. Essentially what it has is two constitutional rights pitted against you, and you have the government acting as both the sovereign and as the employer. So they can't abuse their rights as an employer, and have you giving up your right, your Fifth Amendment right to silence, because they're still the big bad government. If you work for me and I'm a private entity, and I wanted to interview you and ask you questions, you have to answer my questions no matter what. There's no such thing as this Fifth Amendment right to silence or voluntary compelled, because I'm not the government. I'm not a state actor. It's because the government's acting in that situation on two fronts, in two separate capacities. The sovereign, in this case the prosecutorial entity, and your employer, it pits these two constitutional rights against each other. So the Supreme Court has said, if you force them to talk, if you make them talk as a condition of their employment, they get use immunity. Okay? So you want to ask two questions. Is this voluntary? Is this compelled? If it's a voluntary request for an interview, no thank you. I'll cooperate in any other way that I can. But if you're telling me this is voluntary, I'm going to decline at this point. If it's compelled, then you're going to have to participate. And this is, this really underscores the importance, I think, of why you need, the insurance. Is this is stuff that your lawyer will do. This is stuff that your lawyer will vet for you. And it's also, it's not comfortable for you to hide behind the Fifth Amendment. You feel you didn't do anything wrong. Firefighting is dangerous. This stuff happens, and you come in and you invoke your Fifth Amendment right to silence, and we've all watched that on TV. It just makes you feel and makes you look guilty. Having your lawyer explain to the IG that we're not going to come talk until it's compelled, is a whole lot easier on you. Trust me.
Thank you, Tony. Our next question is, how does your insurance differ from others who offer a similar product?
Good. I'm glad you asked that question. And I'll quickly run through it, and then I'll also encourage people to get on our website, and there's a specific enumeration of all these items on there. First is ours is a little bit cheaper. The legal representation for civil matters is not capped at the sublimits, and what that means is for civil matters you have the full $1 million and $2 million to use both for your legal defense and to pay any debt judgment. One of the other policies caps that at your $200,000 sublimit that they have for your administrative defense. Our claims handling is done by a separate third-party claims handler outside of feds, so we avoid any conflicts of interest. They don't have a dog in a fight. They're simply going to review the policy, review your situations, and make a decision. Other companies do all their claims handling in-house, so there could be this appearance of a conflict of interest. Regarding criminal matters, one of the policies have what's called one of our competitor policies has what's called a clawback provision, and what this means is they have the right to get legal fees against you if they defend you in a criminal matter and you're ultimately adjudged guilty. Okay, we don't have a similar type clawback provision. we cover you in a criminal matter. Unfortunately, if there's a negative finding, that's the end of it. We don't try to come after you. We don't try to come after you for those fees. Some other small things, we give pro rata refunds. If you retire or otherwise leave federal service, we don't have a lot of unnecessary administrative fees. We only have a maintenance fee for enroll and payroll deduction, but there are no other administrative fees. That's important because you can't get reimbursed for administrative fees. We provide the 2 free half-hour legal consultations for free. Those are for things that aren't necessarily covered by the insurance. Other policies either don't have that or they try to charge you extra for that. Having said all that, the biggest difference I will tell you are 2 things. Our commitment and know-how, okay? Our commitment and our legal defense are the biggest differences, in my opinion. The legal defense is done by, lead panel is done by Shaw, Bransford, and Roth, which for well over 25 years, have been the leading experts on federal personnel law. And as it applies to you, the wildland firefighters, they were the legal team that were involved in defendant managers in 30 Mile, in Kramer, in Esperanza. They've been out speaking on this topic. They've written and promoted articles. They understand your community, the exposures you have better than any other, in my opinion, any other law firm out there. Finally, our commitment and know-how. I'm a former federal employee. We're really trying to run a program that does right by federal employees, does right by federal wildland firefighters. I think if you ask around the community, you get on wildlandfire.com, you reach out to other areas in the community, and you ask them about us, you ask them about me, you will see that we really go the extra mile to make sure that you get the defense that you need. We're really a part of your community. We're not just here to sell you insurance. And finally, I would just, look at our website. There's a reason all the leading federal employee associations, are endorsing us. And I really think it's our customer service and the quality of care that we give you, and in the unfortunate event that you have to file a claim.
Thank you, Tony. I don't believe this is a question. I think this is a statement that I'm just going to read, please, by one of our participants. In regards to the guy starting his career, he will be an ICT 5 soon, hopefully, thereby able to lead a squad and IC a small fire, thereby liable. And then I'm going to go on to our next question. So I am a prevention technician GS9. I am an ICT4 and often the first on scene, and I deal with the public regularly, mainly public contacts. I am also a public information officer too, as well as a helicopter manager, and I often work at air tanker bases. I am assuming I would be a strong candidate for PLI, even though I am not strictly on the fire line. Is fire prevention technician covered as one of the reimbursement positions?
I believe so. I believe the fact that you can be, an IC4, as you mentioned, that also echoes the person who gave the statement regarding Dylan's question. I believe you are eligible, but I would just ask you to take a look at that enclosure A that I talked about, and if you just send us your email after, we have your email. So if you just let Kathy know, she can figure out who you are. We'll send you that policy, and it enumerates all the positions. But I believe you are eligible. I'm about 99% sure. But I always want you to check that policy so you know for sure before you purchase the insurance.
Okay, sir, I have your email, so I will look that up for him, Tony. The next question is, how does PLI differ from union coverage?
It's a good question. PLI differs from union coverage in, well, like 2 major ways, or 2.5 major ways, if you will. All right. Union if you're a member of a union, NIFI in this case, what you get if there was an administrative action taken against you, you would be able to have union representation throughout the administrative investigation, agency level disciplinary action to file a grievance, and if the union agreed, you can arbitrate that matter. But they don't, it's a union's decision whether to grieve it or not. That's the only overlap between the Fed's liability insurance and union protection, is the coverage you get for administrative claims at the agency level. Okay? Your union protection does not give you, your union affiliation does not give you protection against civil claims, does not provide you indemnity protection, does not provide you a lawyer if you're sued personally. It also does not provide you protection for the criminal investigations, which I think is the biggest thing you ought to be concerned about as a firefighter. You know, you're on your own for that. Also, for administrative stuff, to appeal it outside of the agency, you need the union's permission to go to arbitration. With us, the policy provides for a legal defense outside of the agency, so long as you still have legal fees available to defend. Now, having said that, I'm a strong proponent that people should have both. If you're eligible to be in the bargaining unit, you should be a dues payer. You should be part of that, because in addition to providing some defense in an administrative matter, you get tremendous amounts of advocacy, from your union, on Capitol Hill, on national level stuff, and there's strength in numbers there, and that helps. So I would always encourage people to support their union that way, in addition to getting the liability protection to protect them where they have other vulnerabilities.
Thank you, Tony. The next question is, for those people that are talking about being defended on the different fires, how much on average did those people with PLI pay out of pocket versus those without PLI?
I don't know how much people paid who didn't have PLI. The representation that I personally was involved in, everybody had the insurance, so they paid zero. They didn't pay anything. I could tell you that had they paid, their legal fees, would have been between $100,000 and $200,000. So I don't know the others who didn't have representation through the law firm where I practice. I just don't know, but I have to imagine it's somewhere in the neighborhood, or they negotiated some flat fee type thing. It's expensive. More. I mean, what it costs you to buy insurance is more. Typically is less than it's going to cost you to pay for an hour of a lawyer's time.
Another question is, so I thought it was interesting that you said we can make good, sound decisions and still be held liable or accountable. Would you expand your thoughts on why that is? Why is that reasonable?
I don't. Whether I think it's reasonable or not reasonable really doesn't matter. Okay, it's I don't think it's reasonable. Okay, I'm on the side of defending you. I point that out. That it's that they do it at a convenience to find accountability. I believe agencies often look for scapegoats, want to find people accountable, to CYA, to appease various stakeholders, whether it's a loved one, a parent, Congress, news media, other people. They'll grasp at anything to be able to do that. And the point that I was trying to make is, with the benefit of hindsight, you come back and look, it's a very pliable rules. They can be manipulated, to serve someone's other purpose. So I don't think it's reasonable. I don't think it's necessarily fair. I'm just telling you that's the landscape. That's what's happening, and that's why it's even more important that you need to get the insurance. One of the biggest barriers I've found in starting this company, and he did this on a platform of education. I just felt not enough people were aware of what the protection provides. And when I got out there and started lecturing a lot, the thing that surprised me the most is that I found that people who made a decision not to buy the insurance were doing so, and who knew about it, were doing so because they felt they had to envision themselves doing something wrong. And nobody, you guys are, most of them know, dedicated, well-intended civil servants, that are going, across all the different agencies. You love your jobs, you love what you're doing, you're trying to do everything right. You don't think you're going to do something wrong. But the point I was trying to make is you don't have to be doing anything wrong. Things happen. When accidents happened, unfortunately, the knee-jerk reaction from the agencies are to find someone accountable.
Tony, I want to read you a statement that came through from a group that the last question was from that group. It says, thanks, I got a group of 11 together to listen to this, so these questions are coming from several people. Good job, folks. Another question from that group is, I'm a firefighter as well as a FPO, Forest Protection Officer, meaning I write federal violation notices. Do I need law enforcement PLI as well?
No, good question. We're doing for today's presentation, it's tailored to the wildland firefighter. Last week I did one tailored to federal law enforcement officers. The liability insurance covers you no matter what kind of federal job you're doing. And if you've got various responsibilities, it's going to cover you for all those. The only reason we do different webinars and maybe provide different information is because often the exposures are a little bit different for particular groups. Like, for example, law enforcement officers are a lot more vulnerable for civil lawsuits. Okay? So the fact that you're performing wildland firefighter duties and some law enforcement duties doesn't affect your insurance coverage. It covers you for both. It just means you've got a little bit more exposure than the others. So it's the same insurance. It covers you no matter for any professional service that you're doing for the federal government. It covers you if you move from the Forest Service to BLM to another agency. It moves with you, and you're automatically still covered.
Just a few more questions, Tony. From the employee perspective, if you have feds, would there be any help against being unfairly terminated by a supervisor who has high need to control?
The policy covers disciplinary action. So long as you're being disciplined for something that involves you doing your job, not something outside of your job, if you've got liability policy, it will protect you in that regard, regardless of what the motives are of the manager.
Thank you. Are temporary seasonal employees eligible for 50% reimbursement?
Again, I believe the answer to that is yes, so long as you meet the definition and you're in one of the jobs that are listed in that enclosure A if you're Forest Service. But again, we will provide you that policy, and ultimately it's an agency decision. So we always want you to go ask that question from the agency and let them tell you yes before you buy. But I believe even if you're temporary and you're going to be an IC3 or any of these things, you're going to manage fires, you're still going to be eligible for the 1/2 reimbursement. And for that matter, I should point out the people that are hired back temporarily under the AD plan, administratively determined plan, those individuals are also eligible for the Fed's liability insurance. And that would lead me to believe that temporary folks are equally covered for the reimbursement.
Okay, Tony, thank you. I am out of questions, but I do have a gentleman that has had his hand up, so I'm going to unmute him for you. His name is Pete.
Disregard.
No question?
Okay,
I think he
sorry
was just
about
playing
that.
with the controls, which is.
Sometimes that happens. Okay.
Which is.
We are out of questions, Tony.
Okay, everybody who stayed on, those are excellent questions. That's what we wanted out of these. So hopefully you stayed on and got that additional information, because it really is tough to put it all in a 15-minute presentation. I hope you feel you have enough information to make a decision on whether you need liability insurance or not, and if it's a yes, we hope you go with us, and take care and be safe.